distinguished members of the court. Counsel who are appearing before you today would like you to know how honoured they are to do so. This is not just polite lip service, it's obvious given how much respect and confidence that this World Court, the principal judicial organ of the UN, the World Court, inspires and gives a solid weight to the conviction shared by those who come to this bar, that international law is not an empty promise. Today, the feeling which strikes me, which strikes us all, not only on this side of the bar, but everywhere in Ukraine and beyond, everywhere in the world, is that of extreme urgency to hear your court play its full part in the action undertaken by the United Nations and the world. Extreme urgency to bring to an end without delay this war purporting to prevent an alleged genocide and the punishment launched against leaders, launched against Ukraine, its leaders, its people, its identity, against its very existence by President Vladimir Putin on 24 February 2022. This under the guise of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. Now, some people will say that 24 February 2022 is a black day in the history of the Convention for 48. In truth, at that date, Russia reduced it to confetti. Your court, Madam President, distinguished members of the court can, and I believe must, make it whole again. And I'm sure that you will do so, but that will take time, and time, well, that's one thing we don't have. And that's why Ukraine requests your court to act swiftly, indicating the provisional measures requested. You can do it. And Ukraine believes that you must do it. All the conditions are met for this, and I will demonstrate, as you've already heard, that your jurisdiction, which need only be prima facie, is established. Following me, Mr. Zayons will demonstrate the total emptiness of those allegations of genocide proffered by Russia. Then Ms. Cheek will show that those rights whose protection is sought by Ukraine, the right not to be victim of a delusional interpretation and application of the Genocide Convention, the right not to see its territory devastated, its population terrorized in the name of the Genocide Convention, that these rights claimed by Ukraine are, according to the accepted formula, at least plausible. Mr. Gimblett will tell you we have unfortunately moved well beyond the risk of irreparable prejudice and that there is extreme urgency. I mean, really, it is the wholly relevant term here to avoid more death and destruction. Finally, Professor Coe will explain why the provisional measures requested by Ukraine are appropriate in the extraordinary current circumstances of the case, and the co-agent of Ukraine will wind up this morning's session. So let me come now to prima facie jurisdiction. In this respect, Madam President, Ukraine would like to point out that Russia decided not to appear before you without giving the least explanation, justification for that. Let me point out that in other cases, Russia argued tooth and nail that you lacked jurisdiction. As prolix as its able counsel were then, here Russia remains silent. You will see there Russia's acknowledgement that they cannot challenge the prima facie jurisdiction of your court. And Ukraine shares this opinion. Madam President, distinguished members of the court, as you have recalled a number of times, and recently indeed again, I quote, the court may indicate provisional measures if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded. but need not satisfy itself in a definitive manner, that it has jurisdiction as regards the merits of the case. Now, your powers and competencies are founded on Article 36, Paragraph 1 of your statute and Article 9 of the Genocide Convention. This latter text is well known to the court, but I'm going to quote it nonetheless. Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relative to the responsibility of a state for genocide or for any other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. End of quote. Now, ratione personae jurisdiction requires no debate. Russia and Ukraine are both parties to the Genocide Convention, and neither of them have made a reservation which is currently in force. Regarding ratione materiae jurisdiction, what you have to check at the stage of provisional measures is the prima facie existence of a dispute relative to the interpretation, application, or fulfillment of the convention. Now, the key points of your case law with respect to the concept of dispute, which are recalled in the Marshall Island case, can be summarized as follows. A dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between parties. For a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides hold clearly opposite views concerning the question of the performance of non-performance of certain international obligations. Now, this is a substantive question. It's not formalistic or procedural, and it calls for an examination of the facts. Now, to this end, the court will, inter alia, take account of all declarations or documents exchanged in multilateral fora, and in so doing, the court accords particular attention to the author of the statement or document, their intended or actual addressee, and their content. The behaviour of the parties may also be taken into account, specifically in the absence of diplomatic exchanges. The disagreement need not necessarily be stated expressis verbis. As in other matters, the position or the attitude of a party can be established by inference, whatever the professed view of that party. In particular, the court has ruled that the existence of a dispute could be inferred from the failure of a state to respond to a claim in circumstances where a response is called for. Now, Madam President, distinguished members of the court, it is clear that Ukraine has many grievances to assert against Russia. But what is before you is a very delineated dispute. It's a dispute relative to the interpretation, application, or fulfillment of the Genocide Convention. And it takes a twofold form. The first expression of this dispute relates to the fact that, according to Russia, Ukraine has committed genocide in the oblasts of Donetsk and Luhansk. This accusation lies at the heart of the decision of the Russian Federation of 2022. It is the only legal justification advanced by Russia to justify its attack on Ukraine as a whole. Now, this serious accusation doesn't date from 24 February 2022. In fact, Russia has repeated it consistently, even ever more vehemently for the last 8 years, as I shall now show. But before doing that, Madam President, may I point out that all the facts that I'm going to mention are all duly established in documents which can be found in the judge's folders, so you can consult them when that suits you. I would also like to point out that I will quote certain documents, some of which are in Russian. I'm going to quote them in a French version, which isn't official, which I think is reliable, in order to simplify the work of the interpreters. Now, for your comfort, a translation in English of the Russian language documents is also available in your case files. So let me come to the facts, in particular to the allegations of genocide. As of 2014, the newspaper Nezavisimaya Gazeta, edited in Moscow, published an article, the French version of which was edited by the magazine Courrier International, entitled, I quote, "Ukraine-Russia Accusation of Genocide Towards a Kosovo-type scenario, question mark." Its author underlines that now the word genocide is heard more and more clearly, end of quotation, but pointed out that it will be extremely difficult for Russia to get Western countries' recognition of genocide in eastern Ukraine, end of quotation. Now, this article in the press came at the same time as the Russian Federation's investigation committee's opening of an inquiry into, I quote, "the genocide of the Russian-speaking population living in the Oblast of Luhansk and Donetsk." The Russian Federation's investigation committee is an official Russian agency mandated with criminal prosecutions at federal level, which reports directly to the President of the Russian Federation. Its communique indicates that, and I quote, "The investigation found that during the period from 12 April 2014 to the present, in violation of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, as well as other international legal acts prohibiting genocide, unidentified persons from among the top political and military leadership of Ukraine, the armed forces of Ukraine, the National Guard of Ukraine, and the right sector, I don't know how to translate that, gave orders to completely destroy specifically Russian-speaking populations living on the territory of the Donetsk and Luhansk republics." End of quote. In January 2015, new penal prosecutions were set in train by Russia following the alleged bombing of the east of Ukraine by the Ukrainian army. The investigation committee of Russia asserted, I quote them, "Such acts carried out by the Ukrainian military constitute especially grave crimes, not only under Russian law, but also under the norms of international law, in particular the Convention on the Prevention and Punishment of the Crime of Genocide and others." End of quote. In February 2015, the world press, for example, Le Soir in Belgium, pointed out that the President of the Russian Federation, Vladimir Putin, had asserted that the refusal of the Ukrainian authorities to supply gas to the provinces in the east, I quote, "already looked like genocide," end of quotation. On 10 September of the self-same year, an official communique of the Investigation Committee of Russia announced that it was going to initiate new prosecutions against an indefinite number of Ukrainian officials, including the Minister of Defense and other named military officials, on the grounds that they had allegedly violated, inter alia, the Convention on the Prevention and Punishment of Genocide. And during an interview with Russian media, Vladimir Markin, official representative of the Russian Prosecution Service, said, I quote him, "I would like to remind you that current Russian legislation, as well as the norms of international law, allow Russian investigative bodies to prosecute these people." And we're talking about extraterritorial jurisdiction where the universal principle applies. The same official spelled out that Russia intended to exercise this extraterritorial jurisdiction, quoting, in cases provided by an international treaty of the Russian Federation if foreign nationals have not been prosecuted in a foreign state, end of quotation. In September 2017, the Russian Investigation Committee announced criminal proceedings against 20 other senior officials in Ukraine's defense ministry, including the Ministry of Defense himself. According to the representative of the Investigation Committee, the same Vladimir Markin, I quote him, these persons, in violation of the Convention on the Prevention and Punishment of the Crime of Genocide and others, exercising the general control over military operations, gave deliberately criminal orders to the soldiers of law enforcement agencies of Ukraine to conduct targeted artillery shelling of civilian infrastructure. In November 2021, the President of the Russian Federation adopted a decree, a ukaz, with respect to eastern Ukraine. The ambassador of the Russian Federation in the contact group for the settlement of the situation in eastern Ukraine, Boris Kislov, stated then that this decree was a response to the actions of Kyiv, I quote him, which actually fall under the United Nations Convention on the Prevention of Genocide, end of quote. Now, Madam President, distinguished members of the court, this is not some trivial event. Indeed, the accusation of a violation of the UN Convention on the Prevention and Punishment of Genocide, repeated year after year by the Russian prosecution service, had just been rehearsed and ratified by one of the senior officials of the Russian Federation regarding international relations between Russia and Ukraine. The accusation from then on clearly took on an international character and was largely relayed by official media of Russia. Let's not get it wrong, agents, the TASS agency, of course, but also by RIA Novosti, other Russian media, clearly understanding the message, then put up headlines. What Kyiv is doing in the Donbass falls under the Genocide Convention. On 9 December 2021, the President of the Russian Federation maintained to a journalist of Russia Today that what's happening, and I'm quoting him, what's happening right now in the Donbass, you and I can see it. We know it. That is a genocide that you have mentioned. The assertion this time from the most senior official of the Russian state, its president, was obviously taken up by all official Russian media, inter alia TASS agency, but also by the world press. In France, for example, in Le Point. On 10 December 2021, the Vice President of the Duma Committee for International Affairs, Alexei Chepa, told Russia Today, that's official Russian media, that he unreservedly supported the words of the President of the Russian Federation. I agreed wholeheartedly, he said. His people are purely and simply being annihilated. The article of Russia Today recalls furthermore the position of Ambassador Boris Kislov, who I mentioned a little earlier, who had posited that Russia's grievance with Ukraine fell under the Convention of the United Nations on the Prevention of Genocide. On 16 February 2022, during the press conference at the end of a meeting between the President of the Russian Federation and the German Chancellor Olaf Scholz, which concerned this meeting concerned specifically the threat of military action of Russia against Ukraine, the Russian president justified in advance such an action by accusing Ukraine of genocide. On 18 February 2021, the president, error in my text, that should be, of course, 18 February 2022, the president of the Russian parliament, Vyacheslav Volodin, accused Ukraine once again of committing acts in the east of the country, acts which international agreements prohibit. And he spells it out clearer. If it's not genocide, then what is it? End of quotation. I quote him once again, warning that, I quote, the authors doubtless will be punished. Now, 3 days later, in his speech of 21 February 2022, justifying his decision to recognize the sovereignty of the so-called republics of Donetsk and Luhansk, the president of the Russian Federation accused, and I'm quoting him now, the so-called civilized world, which our Western colleagues proclaimed themselves the only representatives of, prefers not to see this, as if the horror and genocide faced by nearly 4 million people did not exist. But they do exist, end of quotation. In his speech of 24 February 2022, rehearsing once again the allegations reiterated by Russia since 2014 under the guise of the Genocide Convention, the Russian head of state accuses once again Ukraine of genocide, stating that the military action launched on that fateful day, I quote him here, the purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime. On 25 February 2022, Russian Federation's ambassador to the EU, Vladimir Chisov, confirmed in an interview with Euractiv that the allegation of genocide against Ukraine was done so with reference to the Genocide Convention. On 28 February 2022, the Russian Federation's foreign minister came back to the fray, accusing this time the EU of having taken the side of, I quote him, the Kiev regime, which has embarked on a policy of genocide of its own population. Now, Madam President, distinguished members of the court, it serves nothing to accumulate any more evidence showing that what Russia reproaches Ukraine of, and which formed the basis of its decision to punish Ukraine militarily, is to have allegedly committed acts contravening the UN Convention for the Prevention and Punishment of Genocide. Is this the cause of the dispute? Well, how could one possibly doubt it? Ukraine deeply disagrees with this allegation, which they always have found as totally grotesque. Ukraine let Russia know that time and time again, starting September 2014. In a report of the BBC, the advisor of the Minister of the Interior of Ukraine pointed out the Ukrainian prosecutor's offices had initiated penal prosecution against agents of the Russian Investigation Committee accused by Ukraine of aiding a terrorist organization in the Donbass and obstructing the application of the law and the work of state agents precisely because they had accused Ukraine of genocide in the Donbass. The advisor added that according to Ukraine, those accusations of genocide made by the suspects had as their sole objective the justification of the occupation of the Donbass. Now, I could stop there. It's so evident that when one state accuses the other of breaching the Genocide Convention and the other initiates judicial proceedings against the agents of the former on the grounds that they've been making false allegations, that a dispute relative to the interpretation, application or fulfillment of the Convention on Genocide is incontrovertibly established. Furthermore, the dismissal of Russian accusations as totally unfounded wasn't limited to Ukraine. You will remember, because it happened less than a month ago, on 16 February 2022, the US State Department had denounced the accusation of genocide advanced by Russia as aimed at fabricating a pretext to launch a military invasion of the Ukraine. As to the German Chancellor, he denounced the Russian accusation of genocide as laughable, triggering the ire of the Russian Federation's foreign minister. As to Ukraine, well, it once again showed its disagreement with Russia via its foreign minister. On 23 February 2022, before the UN General Assembly, when the ambassador of Russia to the United Nations organization, Factual, justified the lawfulness of the Russian recognition of the independence of Oblast of Donetsk and Luhansk, saying, you can see it on the left here of the screen, given the flagrant genocide and the trampling of the most important of human rights, the right to life, our country cannot remain indifferent to the fate of the 4 million people in the Donbass. Flagrant genocide? Mr. Kuleba, Ukraine's foreign minister, responded, I quote him, Russia's accusations of Ukraine are absurd. Ukraine has never threatened or attacked anyone. Ukraine has never planned and does not plan any such action. Russia's actions and statements are outrageous, horrific, and go far beyond threatening Ukraine. In fact, in his address this week, Russian President Vladimir Putin overtly denied Ukraine's right to exist. End of quotation. On 26 February 2022, Ukraine's foreign minister forcefully reiterated the dismissal by Ukraine of accusations of violation of the Genocide Convention as being baseless. Let me quote the communiqué, which the judges can find in their folders. Ukraine strongly denies Russia's allegations of genocide and denies any attempt to use such manipulative allegations as an excuse for unlawful aggression. The crime of genocide is defined in the Genocide Convention, and under that convention, Russia's claims are baseless and absurd. Russia's claims of genocide as justification for its lawless conduct are an insult to the Genocide Convention and to the work of the international community in preventing and punishing the world's most serious crime. End of quote. Madam President, distinguished members of the Court, these facts speak for themselves. They confirm the existence, at least prima facie, of a dispute between the parties, which can be summed up as follows. Russia accuses Ukraine of engaging in acts and in a policy of genocide within the meaning of Article 2 of the Convention. Ukraine retorts that these allegations are absurd, even odious, because they are obviously legal window dressing for an armed aggression. This dispute falls within the provisions of Article 9 of the Convention. Your prima facie jurisdiction to entertain it is thus established.
But this does not exhaust the subject, because, as I said, the dispute includes a second, even more serious aspect, which concerns the actions that a state can or must take with regard to another state that is also party to the convention that it accuses of genocide. According to Russia, the denunciation of the alleged genocide that it blames on the Kiev regime, calling it Kiev, the so-called Nazi junta led by President Zelensky, would authorize it and its continuation and to punish alleged perpetrators by means of a war against that state aimed at protecting the victims of the alleged genocide, tracking down those perpetrators, alleged perpetrators, and bringing them to trial. It is true, Madam President, distinguished members of the Court, that Article 1 of the Convention provides that states have the obligation to prevent and punish genocide. That is to say, in the words of your Court, and I quote, all means reasonable available to them should be used so as to prevent genocide so far as possible. End of quote. It is also true, as the Court held, that according to Article 1 of the Convention, and I quote, the obligation of each state to prevent and to punish the crime of genocide is not territorially limited by the Convention. These are the words of the Court. End of quotation. However, nothing in the Convention authorizes a state to enter by force the territory of another state to prevent or punish or prevent or punish genocide. And indeed, you held in 1986 in Nicaragua versus the United States that, and I quote, where human rights are protected by international conventions, that protection takes the form of such arrangements for monitoring or ensuring respect for human rights as are provided for in the conventions themselves. End of quote. And you also added that while each state makes its own assessment of the human rights situation in a third country, and I quote the Court once again, the use of force could not be the appropriate method to monitor or ensure respect of these rights. End of quote. However, it is exactly the opposite that Russia claims through, in particular, but not only, its president. In his 21st February 2021 speech, referring to the events in Odessa in 2014, when the first allegations of genocide were made, the Russian president said, and I quote, "One shudders at the memories of the terrible tragedy in Odessa where peaceful protesters were brutally murdered, burnt alive in the House of Trade Unions. The criminals who committed that atrocity have never been punished, and no one is looking for them. But we know their names." That's what the president said, the Russian president. And this was in February 2021, that we know their names and we will do everything to punish them, find them and bring them to justice. End of quote. The same leader also argued in his 24th of February 2022 speech, announcing the so-called special military operation that, and I quote, its goal is to protect the people who have suffered abuse and genocide at the hands of the Kyiv regime for 8 years. The purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kyiv regime. To this end, we will seek to demilitarize and denazify Ukraine, as well as bring to trial those who perpetrated numerous bloody crimes against civilians, including against citizens of the Russian Federation. End of quote. In other words, according to Russia, there is no other possible rationality for the justification put forward by its president at the very moment he ordered the invasion of Ukraine. The Convention on the Prevention and Punishment of Genocide gives him the right, perhaps even the duty or the responsibility, to prevent by denazifying and to punish by hunting down and by bringing to trial the alleged genocide perpetrated in Ukraine by means of a special military operation. Madam President, distinguished members of the Court, Ukraine strongly disagrees with Russia's interpretation, application, or fulfillment of the Convention by Russia. As for Russia, it could not have been unaware that its views were positively opposed by Ukraine. What Russia could do under Article 8 was to call upon the organs of the United Nations. What Russia could have done under Article 9 was to file an application against Ukraine before this court. Ukraine argues that Russia, on the other hand, has strictly no right under the Convention to take the military action that began on 24th of February 2022, because, unlike Russia, Ukraine considers, as your court did in the Bosnia-Herzegovina genocide case, that on the basis of the Convention, and I quote, "It is clear that every state may only act within the limits permitted by international law." End of quote. Ukraine is resisting. Ukrainian men and women are suffering. Ukrainian men and women are dying. They could not have demonstrated their dispute with Russia more forcefully. Madam President, members of the court, the dispute over the interpretation, application, or the fulfillment of the 1948 Genocide Convention between Ukraine and Russia is not just about angry words. It is also forged in iron, in flames, in blood, in screams and tears. Your prima facie jurisdiction to hear this case is beyond doubt. Ukraine is asking you to exercise it by indicating the provisional measures that it has requested you to order. It is asking you to give substance to the conviction shared by a lot of those who stand here that international law is not just an empty promise. That concludes my remarks, Madam President. I would like to thank you for your very patient attention, as always, and I would respectfully ask you to give the floor to Mr. David Science. Thank you.
And I now give the floor to Mr. David Science. You have the floor, sir.
Madam President, members of the court, I am honored to appear before you on behalf of Ukraine. Ukraine comes to this court because of a grotesque lie and to seek protection from the devastating consequences of that lie. The lie is the Russian Federation's claim of genocide in Ukraine. The consequences are unprovoked aggression, cities under siege, civilians under fire, humanitarian catastrophe, and refugees fleeing for their lives. You have just heard why Russia's claim of genocide, opposed by Ukraine, creates a dispute under the Genocide Convention over which the court has jurisdiction, certainly on a prima facie basis. I will now step back to explain the factual context of Russia's allegation so that the court can understand its falsity and the lack of any hint of plausibility. Russia would have the world believe that Ukraine launched a genocidal war on its own people in the Donbass. Even a basic understanding of the facts shows this to be false. In addressing the facts, 2 points should be stressed. First, the full history of Russia's mistreatment of Ukraine is not before the court. This case is about false claims of genocide in the war Russia launched to purportedly prevent and punish alleged acts of genocide. I will focus on only the background that will be most helpful to the court in appreciating the falsity of Russia's allegations. Second, in political forums, Russia presents a narrative based on forgeries, fakes, and distortions. In this legal forum, I will not present one country's narrative against another's. I will present the fact as documented by UN human rights bodies and officials and similarly credible, neutral observers. Madam President, in February 2014, the Ukrainian people rose up in a revolution of dignity. Russia responded with aggression, invading and occupying the Autonomous Republic of Crimea and the city of Sevastopol. Then, as now, Russia's aggression was based on lies. Russia first denied that it had used its military. Then, President Putin admitted it. Then he claimed without basis that, quote, the Russian-speaking population was threatened, end quote. The international community rejected Russia's actions, and the UN General Assembly passed Resolution 68262, overwhelmingly reaffirming the territorial integrity of Ukraine, including Crimea. With Crimea occupied, Russia tried to apply the same tactics to the Donbas region of eastern Ukraine, spanning the Donetsk and Luhansk oblasts. But Russia did not find support. So instead, it looked to illegal armed groups to advance its agenda. These groups called themselves the Donetsk People's Republic, or DPR, and the Luhansk People's Republic, or LPR. This is how the UN Human Rights Monitoring Mission in Ukraine described the DPR and LPR in May of 2014, the earliest days of the conflict. The mission is concerned with the undermining of human rights protection and guarantees of fundamental freedoms for the population of the town where buildings are occupied by armed persons, as well as the broader population of eastern Ukraine. Specifically, the UN mission is concerned about the rise in the number of reported cases of intimidation, harassment, and killings, as well as the wave of abductions and unlawful detentions of journalists, activists, local politicians, representatives of international organizations, and members of the military. 1 month later, the UN Human Rights Mission reported as follows: violence and lawlessness have spread in the regions of Donetsk and Luhansk. Having gained access to deposits of weapons, the armed groups increasingly started spreading violence. Increasingly, attacks target ordinary people who take no part in the fighting. And here is the UN Human Rights Mission 1 month after that, in July 2014. Grave human rights abuses have been committed by those armed groups. And it must be remembered that these groups have taken control of Ukrainian territory and inflicted on the populations a reign of intimidation and terror to maintain their position. Ukraine was therefore faced with illegal armed groups controlling territory, murdering civilians, and waging a campaign of terror. Any responsible government in this situation would work to restore law, order, and respect for human rights. And that is what Ukraine did. The early history of Ukraine's operation is documented, again, by the UN monitoring mission. It reports on Ukraine's efforts to limit the operation, calling an early stop to it in observance of Easter. But Ukraine was compelled to resume the operation, quote, following the discovery of the bodies with alleged signs of torture of Volodymyr Rybak, Horlivka city councillor, and Yuri Popravko, a student and Maidan activist from Kiev, in a river near Slovyansk on 19 April. This refers to a well-known incident discussed at the UN Security Council, in which Mr. Rybak was kidnapped, tortured, and assassinated by the DPR for the crime of raising the Ukrainian flag. Ukraine resolved to secure its territory and protect its people. On their own, and without meaningful popular support, it is difficult to imagine the DPR and LPR maintaining any territory for long. But these illegal armed groups found eager sponsors in Russia. In December 2014, the UN Human Rights Monitoring Mission reported that, quote, "The total breakdown in law and order and the violence of fighting in the eastern regions," end quote, was, quote, "fueled by the cross-border inflow of heavy and sophisticated weaponry as well as foreign fighters, including from the Russian Federation," end quote. The ICC Office of the Prosecutor has likewise tied the increased intensity of fighting to influxes of troops, vehicles, and weaponry from the Russian Federation. Over time, Russia's influence and control and overt role in the conflict grew, and in 2018, Ukrainian legislation declared the Donbas occupied territory. Fueled by Russia, the carnage in eastern Ukraine grew. I will highlight only one example: the shelling of a residential district in Mariupol on 24 January 2015. 30 civilians died in the attack. According to the UN Secretary General, the attackers fired indiscriminately into civilian areas. The Undersecretary General for Political Affairs elaborated that they knowingly targeted a civilian population. I should add that Mariupol is a Russian-speaking city. Russia's claim to be the protectors of Russian-speaking people in Ukraine did not protect Mariupol from a barrage of Russian rockets in 2015. Just as it is not protecting Mariupol today from a Russian siege army that is bombarding the city and cutting off its power, water, and heat. Madam President, members of the court, these are the circumstances in which Russia claims that Ukraine has been committing genocide against its own people. It would be an understatement to say that Russia has provided no evidence for acts of genocide in the course of this conflict. The closest President Putin has come to even explaining his allegation of genocide is to assert, as he did on 21 February of this year, that, quote, "Not a single day goes by without Donbas communities coming under shelling attacks," end quote. This is another flagrant lie for which Russia has offered no support. Shortly, Ms. Cheek will apply the definition of genocide under Article 2 of the Convention and show that no such acts have been committed. For now, I will make 3 factual points. First, Ukrainian civilians on both sides of the contact line have suffered from a conflict which Russia has funded and fueled and increasingly waged itself. Tragically, Ukraine's adversaries have had no regard to the lives of civilians on their side of the line. This is not Ukraine's position alone. It is a fact documented by the UN Human Rights Monitoring Mission, quote, "The armed groups are locating their military assets in and conducting attacks from densely populated areas, thereby putting the whole civilian population at risk." The civilians on both sides of the line are Ukrainian, and Ukraine regards every civilian death in this conflict as a tragedy. But to claim that Ukraine targets civilians is to distort facts As I noted a moment ago, in the course of this conflict, top UN officials condemned the DPR for knowingly targeting a residential area. You will not find anything that comes close to that about Ukraine. Second, if there were attacks on civilians rising to the level of genocide, allegedly warranting an armed invasion, one would think there must have been a massive recent escalation in civilian casualties, at the least. Yet that is transparently not the case. UN human rights monitors have tracked the year-over-year civilian casualties in the conflict. The UN statistics on your screen show a dramatic decrease. These figures, moreover, cover both sides and do not reflect any conclusion of civilians being targeted. To be clear, Ukraine regards as tragic each of the 15 deaths recorded as of the date of the most recent report in 2021. But Russia's claim that Ukraine is targeting civilians is a clear fabrication. Indeed, as recently as 22 December 2021, the OSCE announced a renewed ceasefire agreement. As further explained in a recent report by The Guardian, quote, the OSCE logs regular firing between Moscow armed separatists and Ukrainian soldiers. In recent months, this low-level conflict has been relatively calm, as Russia has moved 150,000 troops to Ukraine's borders, and Ukrainian soldiers have been under instructions not to return fire, end quote. Third, if one point should be clear from my presentation, it is that UN human rights monitors have been meticulously tracking the conflict in Donetsk and Luhansk from its inception to the present. In 8 years of reporting, there is not a single hint of any act of genocide. The OSCE has logged every ceasefire violation, and you will not find in its reports any evidence of genocide. Ukraine has recognized the jurisdiction of the International Criminal Court, whose jurisdiction includes the crime of genocide. The Office of the Prosecutor has been examining the situation for 7 years and found evidence of crimes, but has never said a word about genocide. In short, Russia's claim is that a genocide has occurred under the noses of diligent UN fact-finders, OSCE monitors, and ICC prosecutors. It defies credulity. I turn finally to the present. For months, the world watched Russia mass its forces along Ukraine's borders. Yet as recently as 31 January 2022, at a meeting of the UN Security Council, the permanent representative of Russia reacted angrily to suggestions that Russia planned to invade. He mockingly called on the United States to, quote, show us at least some evidence, apart from bogus narratives fabricated in their own heads, that Russia intends to attack Ukraine. That was a lie. Little more than 3 weeks later, Russia did attack Ukraine. The same permanent representative would justify his country's invasion based on claims of genocide. Another lie. To the end, Russia appeared desperate to manufacture a casus belli. But plans to stage false flag attacks were exposed. Shelling was intensified along the contact line to provoke retaliation, but Ukraine would not oblige. On 17 February, a horrific act of violence did occur in Luhansk Oblast, when a kindergarten was attacked. The OSCE called this indiscriminate shelling. Yet the kindergarten was in government-controlled territory. As Human Rights Watch reported from the ground, the attack appeared to have been committed, quote, by Russia-backed armed groups, end quote. Russia thus found itself eager to invade Ukraine, but lacking any conceivable justification. So Russia settled on its lie. President Putin would dramatically trumpet his accusation of genocide. Russia would recognize the DPR and LPR as independent states on the basis of the genocide they allegedly faced. And Russia would invade Ukraine for the express purpose of protecting the people of Donbass from this fabricated genocide and to punish the supposed génocidaire. With the groundwork laid, the claim of genocide invoked, Russia proceeded to unleash the military aggression that is now horrifying the world. Madam President, members of the court, as we speak, Russian speakers in Ukraine are indeed under attack. Ukrainians are under attack regardless of what language they speak. They are under attack from Russia. Médecins Sans Frontières reported 2 days ago that, quote, the humanitarian situation in Mariupol is catastrophic, end quote. The predominantly Russian-speaking city of Kharkiv is under barbaric attack, with cluster munitions being launched indiscriminately at residential areas. According to a UN report, in the first 6 days of Russia's war, there were nearly as many civilian casualties as in the last 5 years of the Donbass conflict. And that is just confirmed casualties, with the UN recognizing that the real number is much higher and climbing every day. Yet Russia has the gall to massacre Ukrainians and call it protection. Russia has the gall to attempt to overthrow a democratically elected government and call it punishment of Nazis. Russia has the gall to accuse Ukraine of a fake genocide and to rain very real destruction and terror on the 44 million inhabitants of a sovereign state. Madam President, the facts are undeniable. Russia's allegations of genocide are false and outrageous. I respectfully ask that you call on Ms. Marnichik, who will explain the plausibility of the rights Ukraine asserts under the Genocide Convention.
I thank Mr. Zients, and I now invite Ms. Marnichik to take the floor. You have the floor, Ms. Cheek.
Madam President, distinguished members of the court, it is an honor to appear before you again on behalf of Ukraine. I will discuss the rights that Ukraine seeks to preserve through its request for provisional measures. As stated in this court's order on provisional measures in the Gambia versus Myanmar, and here I substitute Ukraine for the Gambia, quote, at this stage of the proceedings, the court is not called upon to determine definitively whether the rights which Ukraine wishes to see protected exist. It need only decide whether the rights claimed by Ukraine on the merits and for which it is seeking protection are plausible. In this case, the rights asserted by Ukraine are plausible, as they are, to again quote the court in Belgium v. Senegal, grounded in a possible interpretation of the Convention. Indeed, the rights that Ukraine asserts are grounded in a good faith interpretation of the Convention, while Russia's use of the Genocide Convention to try to mask its unlawful invasion of Ukraine can only be described as proceeding in bad faith in violation of the Convention. This morning, I will first describe the rights and obligations that exist under the Genocide Convention. Second, I will explain that there is no plausible evidence of genocide in the Donbas region of Ukraine. Third, and finally, I will elaborate on Ukraine's right to demand good faith performance and to not be subjected to abuse or misuse of the Genocide Convention. So let me first describe generally the rights and obligations under the Genocide Convention. Article 1 of the Genocide Convention confirms that genocide is a crime under international law, which the contracting parties, quote, undertake to prevent and punish. This court has interpreted Article 1, observing in the Bosnia genocide case that while the Genocide Convention, quote, does not expressis verbis require states to refrain from themselves committing genocide, that is precisely what the duty to prevent genocide necessarily implies. The court went on to further explain the obligation to prevent genocide as follows, quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect, or those suspected of preparing genocide or reasonably suspected of harboring specific intent, dolus specialis, it is under a duty to make such use of these means as the circumstances permit. Thus, consistent with the object and purpose of the Genocide Convention, to liberate mankind from the odious scourge of genocide, Article 1 includes both an obligation not to commit genocide, as well as a duty to act to prevent and punish genocide. With regard to the duty to act, where there is a serious risk of genocide, states should take preventative measures likely to have a deterrent effect. Further, under Article 4 of the Convention, quote, persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible leaders, public officials, or private individuals. Russia has acted inconsistently with these obligations and duties. It has fabricated a claim of genocide in the Donbas region of eastern Ukraine. It has then justified its military invasion of the entire country as the prevention of that fabricated genocide and as punishment of the alleged perpetrators of genocide through so-called denazification. It has not taken preventive measures likely to have a deterrent effect. As this court explained in its 1951 advisory opinion on the reservations to the Convention on Genocide, the Convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object, on the one hand, is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. In such a convention, the contracting states do not have any interests of their own. They merely have one and all a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the Convention. Consequently, in a convention of this type, one cannot speak to individual advantages or disadvantages to states, or to the maintenance of a perfect contractual balance between rights and duties. The high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all of its provisions. The Russian Federation has flouted these ideals. It does not act with high purposes. It does not act with common interest with the other parties to the Convention. Instead, Russia has invoked the rights and duties recognized by the Convention in bad faith. It has abused and misused them, unilaterally invoking genocide as a legal shield for its unlawful aggression against Ukraine. As Ukraine's cities are destroyed and its people killed in the name of preventing and punishing genocide, the Convention's humanitarian and civilizing purpose is being turned inside out. The object and purpose of the Convention is being defeated. Let me now explain, for the avoidance of doubt, that there is no plausible genocide in the Donbas region of Ukraine. The duty to prevent and punish genocide only arises when there is an actual genocide or a serious risk of it. Contrary to Russia's claims, there is no genocide or serious risk of it in the Donbas region. Genocide is defined in Article 2 of the treaty as, quote, acts committed with intent to destroy a national, ethnical, racial, or religious group, including killings, causing serious bodily injury or mental harm, and deliberately inflicting conditions of life calculated to bring about physical destruction. There is simply no plausible evidence that Ukraine perpetrated such acts in the Donbas region of Ukraine or anywhere else. There is certainly no plausible evidence of the required dolus specialis, or specific intent, which this court has explained sets a high bar for proving the extraordinarily serious allegation of genocide. As Mr. Zients explained, there has been fighting in eastern Ukraine for the last 8 years. This has tragically led to civilian deaths. But civilian deaths in an armed conflict are not, per se, genocide. First of all, the requisite actus reus must be satisfied. In Croatian genocide, your court explained, quote, if one takes the view that the attacks were exclusively directed at military targets and that the civilian casualties were not caused deliberately, one cannot consider those attacks, inasmuch as they caused civilian deaths, as falling within the scope of Article 2A of the Genocide Convention. That is the situation in Donetsk and Luhansk, at least as regard to the actions of Ukraine. There is no plausible evidence that the civilian casualties in the Donbas region were caused deliberately by Ukraine. There is thus no plausible evidence that Ukraine committed killings within the meaning of Article 2. Nor is there any plausible evidence that Ukraine committed any of the various other Article 2 acts against civilians in the Donbas region. Without satisfying the actus reus under Article 2, There is no genocide under the convention. But it is worth mentioning that there is also no evidence of the required mens rea of genocide. No evidence that Ukraine acted with the specific intent of destroying a particular national, ethnic, racial, or religious group. Russia has seemed to suggest that its invasion is to liberate the Russian speakers in the Donbas region. But there are many cities in Ukraine, including in the Donbas region, that are predominantly Russian-speaking, yet do not welcome Russia's actions. To give just one example, Mariupol, a major port city in southeastern Ukraine, it is predominantly Russian-speaking. Yet there are no signs of Ukrainian human rights violations in Mariupol. Today, Mariupol is suffering a humanitarian crisis inflicted upon it by the Russian military, which will not allow safe passage for civilians as the Ukrainian government seeks to protect its citizens there. Quite simply, Russia's sweeping claim of a genocide, which almost 4 million people are facing, has no plausible basis in fact.
Ms. Cheek, may I kindly interrupt you before you begin the next section of your presentation, as it appears that this would be a good time for a coffee break of 10 minutes.
Yes, thank you.
Sitting is adjourned. Please be seated. The sitting is resumed, and I shall now give the floor back to Ms. Cheek to continue with her presentation. You have the floor.
Madam President, members of the court, I will now elaborate on Ukraine's right to demand good faith performance of the Genocide Convention and to not be subject to an abuse or misuse of the Genocide Convention. Without a plausible predicate act of genocide or a serious risk of it, Russia has no duty to prevent or punish under the Genocide Convention. Indeed, in order to act consistently with the object and purpose of the Convention, Russia has a duty not to act in the name of preventing and punishing genocide, since no genocide exists. Simply alleging genocide cannot give a state a right under the Convention to carry out a unilateral military operation against another state in order to prevent and punish the alleged genocide. As held by your court in military and paramilitary activities in and against Nicaragua, quote, where human rights are protected by international conventions, that protection takes the form of such arrangements for monitoring or ensuring respect for human rights as are provided for in the conventions themselves. In any event, while the United States might form its own appraisal of the situation as to respect for human rights in Nicaragua, the use of force could not be the appropriate method to monitor or ensure such respect. Ukraine has a right to demand good faith performance of the Genocide Convention consistent with the Convention's object and purpose. Article 26 of the Vienna Convention on the Law of Treaties sets forth the well-established principle of pacta sunt servanda, quote, every treaty in force is binding upon the parties to it and must be performed by them in good faith. The International Law Commission's commentaries on the draft articles that became the Vienna Convention explain that when drafting Article 26, quote, some members felt that there would be advantage in also stating that a party must abstain from acts calculated to frustrate the object and purpose of the treaty. The Commission, however, considered that this was clearly implicit in the obligation to perform the treaty in good faith and preferred to state the pacta sunt servanda rule in as simple a form as possible. Ukraine stands before you today because Russia has violated the principle of pacta sunt servanda in the performance of its rights and obligations under the Genocide Convention. The Russian Federation has not implemented or fulfilled its obligations under the Genocide Convention in good faith. Rather, it has used a baseless accusation of genocide to justify a so-called special military operation in Ukraine commenced on the 24th of February, 2022. This conduct by the Russian Federation turns the Genocide Convention on its head asserting a right to commit aggression under the guise of a duty to prevent and punish a non-existent genocide is not good faith performance of Articles 1 and 4 of the Genocide Convention. Indeed, it is an abuse of the rights granted through the Convention by each state party to all other state parties. Russia has taken a fundamental peremptory norm of international law, codified in one of the most important human rights treaties that emerged from World War II, and turned it into a charade. The conclusion that Russia's actions violate the treaty gained further support from the decision of your predecessor court in the case of certain German interests in Polish Upper Silesia. There, the court recognized that the misuse of a right was an act, quote, with the character of a breach of the treaty. Here, Russia is misusing its right, or in this case, misusing its duty to prevent and punish genocide. Russia's abuse of its obligations under the Genocide Convention has the character of a breach of the Convention. In the Gambia v. Myanmar, your court decided that the Gambia could invoke the responsibility of Myanmar under the Genocide Convention, concluding that all states have a common legal interest in the protection of rights under the Convention. Your court specifically referred to, quote, the right of any state party to seek compliance with the Convention by another state party. The contracting parties also have a common legal interest in ensuring that actions taken to implement Articles 1 and 4 of the Convention are taken in good faith, without abuse or misuse, consistent with the Genocide Convention's object and purpose. Otherwise, the Genocide Convention would lose the humanitarian character that this court has said is at the core of the treaty. Instead, the Genocide Convention could become a cynical tool enabling violations of sovereignty and human rights. Every contracting party has a right and interest in not seeing the Genocide Convention devalued in this manner. But today, Ukraine stands before you as not just another contracting party to the Convention, but as a party suffering direct harm as a result of Russia's abuse of its rights and duties under the Convention. Ukraine has a right not to suffer grave harm at the hands of a contracting party that disregards the object and purpose of the Convention by falsely cloaking a military invasion as an operation to prevent and punish genocide. As the court recalled on Gabčíkovo Nožimaros, the principle of pacta sunt servanda, as reflected in Article 26 of the Vienna Convention, quote, combines two elements which are of equal importance. It provides that every treaty in force is binding upon the parties to it, and it must be performed by them in good faith. This latter element, in the court's view, implies, in this case, it is the purpose of the treaty and the intentions of the parties in concluding it which should prevail over its literal application. The principle of good faith obliges the parties to apply it in a reasonable way and in such a manner that its purpose can be realized. Applying the principle of good faith performance to this case, a contracting party to the Genocide Convention must abstain from acts that frustrate the object and purpose of the treaty. Certainly, unilateral military action against Ukraine in reliance on a fake allegation of genocide is inconsistent with the treaty's object and purpose. This is apparent if one looks to the preamble of the treaty. Instead of international cooperation, there is unilateral action. Instead of working to liberate mankind from genocide, there are Russian attacks on civilian apartment buildings, schools, and power plants. Instead of reflecting on genocide as having inflicted great losses on humanity, Russia wields the word genocide as a sword to inflict great losses on the people of Kharkiv, Chernihiv, Mariupol, Kherson, Hostomel, Volnovakha, and many others. Quite simply, Russia has not performed its solemn right and duty to prevent and punish genocide in good faith. To the contrary, it has abused its treaty rights to inflict great loss on the people of Ukraine. It is a violation of the Convention for the Russian Federation to act to prevent a genocide that does not exist. It is a violation of the Convention for the Russian Federation to carry out a military action against Ukraine to punish it for a non-existent genocide. Ukraine has a right under the Convention not to suffer from Russia's misuse and abuse of the treaty. Specifically, Ukraine has a right under the Convention not to suffer aggression, war crimes, and crimes against humanity undertaken by the Russian Federation in order to prevent and punish a non-existent genocide. Certainly, in light of the Convention's object and purpose, and the Russian Federation's obligation to perform the treaty in good faith, Ukraine's rights are at least plausible and grounded in a possible interpretation of the Convention, which is all that the Court must find at this stage for provisional measures to be appropriate. If Russia had performed its obligations under the Convention in good faith and done its due diligence to assess whether a genocide or serious risk of genocide actually existed in concreto, Russia would have found no basis to act. As this Court observed in Bosnian genocide, quote, "The notion of due diligence is of critical importance." This due diligence was not undertaken. Instead, on the 24th of February 2022, a mere 11 days ago, President Putin announced a so-called special military operation and stated that, quote, "The purpose of this operation is to protect people who, for 8 years now, have been facing humiliation and genocide perpetrated by the Kiev regime." On that same day, the permanent representative of the Russian Federation to the United Nations stated in an emergency session of the UN Security Council that, quote, "The goal of this special operation is protection of people who have been victimized and exposed to genocide by the Kiev regime." The next day, Russia's ambassador to the European Union justified the invasion by saying, quote, "We can turn to the official term genocide as coined in international law." And of course, as we know, it is the Genocide Convention that defines genocide under international law. As Professor Tuvenan noted, the Russian Investigative Committee has for years claimed that, quote, "that the 1948 Convention on the Prevention and Punishment of the Crime of Genocide has been systematically violated in eastern Ukraine." In November 2021, as yet another example, the Russian ambassador to the Contact Group for Eastern Ukraine, Boris Gryzlov, described certain actions taken by the President of Russia as, quote, "a forced response to the actions of Kiev, which are aimed at escalating the conflict and actually fall under the United Nations Convention on the Prevention of Genocide." Russia has now acted on this fundamentally flawed legal basis, brandishing the language of human rights and claiming a duty to prevent and punish genocide grounded in the Convention. The world is watching a military invasion that Russia launched under the guise of a duty to protect the Ukrainians of the Donbas region from genocide. It was launched to purportedly punish the alleged perpetrators of Kiev, who are implausibly accused of being Nazis. There is a sad and tragic irony here, as Russia's abuse and misuse of the Genocide Convention and Russia's failure to perform its obligations under the Convention in good faith has led to a very real human rights tragedy, as my colleague Mr. Gimblett will explain in greater detail. Under the pretext of acting to prevent and punish genocide in eastern Ukraine, the Russian Federation has sent tens of thousands of troops across Ukraine's northern border with Belarus. Bombs have rained down on the city of Chernihiv in the north. Russian troops are approaching Odessa from the Black Sea in the south. Bombs are raining down on the capital of Kiev in central Ukraine. Russia's military onslaught is in no way limited to eastern Ukraine and belies its justification for its actions. Your court explained in Bosnia genocide, quote, "It would be paradoxical if states were thus under an obligation to prevent, so far as within their power, commission of genocide by persons over whom they have a certain influence, but were not forbidden to commit such acts through their own organs. In short, the obligation to prevent genocide necessarily implies the prohibition on the commission of genocide." The case before you presents a further paradox. It is paradoxical for a state to invoke a breach of the Genocide Convention as a justification for military invasion, to punish Ukraine, its democratically elected leaders, and its people, despite the fact that there is no plausible evidence of genocide at all. I believe Mr. Zion said that Russia lies. Professor Tuvenan pointed to Russia's complete disregard for international law, and both of those statements are true. And when Russia acts to prevent and punish genocide without basis, it offends the humanitarian principles enshrined in the Genocide Convention. The text of Article 1 of the Genocide Convention speaks of the duty to protect and punish. Other provisions of the Genocide Convention give further content to the scope of that duty. Article 4, as previously mentioned, focuses on the punishment of those who commit genocide. Article 5 points to legislation to provide effective penalties for those found guilty of genocide. Article 6 speaks to the prosecution of those accused of committing genocide, and Article 7 speaks of extradition. Article 8 states that a contracting party, quote, "may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations for the prevention and suppression of acts of genocide." But Russia is not focused on any of these things. Instead, it has chosen to wage a war. As the court recognized in the Bosnia genocide case, with regard to the duty to prevent genocide under the Convention, quote, "It is clear that every state may only act within the limits permitted by international law. In this regard, Article 8 of the Convention provides useful context regarding the limits on the duty to prevent and punish under Article 1. Article 8 expressly refers to the UN Charter and appropriate actions for the prevention and suppression of acts of genocide. Article 8 thereby anchors the duty to prevent and punish genocide in the principles of international law reflected in the UN Charter. Madam President, members of the Court, Russia's military action against Ukraine, based on a manifestly false claim of genocide, is inconsistent with the Genocide Convention and exceeds the limits permitted by international law. After you hear about the urgency of the situation and irreparable harm from my colleague, Mr. Jonathan Gimblett, Professor Harold Hanju Ko will address the provisional measures requested by Ukraine, including their link to these rights Ukraine seeks to preserve until the merits of the case can be decided. Madam President, I would now ask you to call upon Mr. Jonathan Gimblett. Thank you.
Thank you for your statement, Ms. Cheek. I now give the floor to Mr. Jonathan Gimblett. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honour to appear before you today on behalf of Ukraine. I will explain why the conditions of irreparable harm and urgency are amply satisfied in the circumstances of this case and require the indication of provisional measures with the minimum delay possible. The Court has repeatedly interpreted its power to indicate provisional measures as arising when irreparable prejudice could be caused to rights which are the subject of judicial proceedings, or when the alleged disregard of such rights may entail irreparable consequences. The Court has also frequently stated that it will exercise that power only if there is urgency, in the sense that there is a real and imminent risk that irreparable prejudice will be caused to the rights claimed before the Court gives its final decision. In assessing whether this condition is satisfied, the Court looks at a variety of factors depending on the facts of the case. For example, in cases involving ongoing conflict, the Court typically considers whether the population at risk is particularly vulnerable. Other relevant factors are the fragility of the overall situation, including the likelihood of aggravation of the dispute, and the risk of recurrence of harm. All of these factors point unambiguously to the existence of an urgent situation in Ukraine requiring provisional measures. As Ms. Cheek has explained, Ukraine has a right not to suffer detriment as a result of the bad faith implementation of the Genocide Convention by another contracting party. Since the 24th of February 2022, the Russian Federation has been engaged in widespread military operations on Ukrainian territory based on its false allegation of an ongoing genocide in Donbass, which it says requires that it intervenes to protect the population of that region. As I will explain next, those military operations have triggered a military, humanitarian, and environmental crisis of a like not seen in Europe since 1945. I will conclude by showing that all of the factors indicating urgency that I outlined earlier are engaged in this crisis. Anyone who has watched the television news outside Russia in the past 11 days knows that President Putin's so-called special military operation for the purpose of preventing genocide is far from the surgical, limited action implied by that euphemism. In reality, Russia has been engaged in a full-scale invasion of Ukraine, attacking simultaneously from the north, the east, and the south, with the objective of capturing the major population centres. It is equally obvious that this invasion has caused, is causing, and will continue to cause huge human suffering, including through the widespread commission of war crimes, the displacement of literally millions of civilians, and the privations imposed on many millions more who are trapped in cities facing savage and indiscriminate bombardment by the Russian armed forces. After describing those human impacts, I will speak briefly about the catastrophic environmental consequences of Russia's actions. It has been obvious since the earliest days of Russia's invasion that war crimes are being committed. As early as the 28th of February, 4 days into the operation, the ICC prosecutor announced that he was seeking authorization to open an investigation into Russia's conduct, while noting that a referral from an ICC state party would allow his team to get to work immediately. Referrals from a record 39 states parties were promptly received, allowing the investigation to be formally opened 2 days later on the 2nd of March. As the Prosecutor General of Ukraine explained in a communication to the Office of the Prosecutor of the International Criminal Court on the 28th of February, which you will find at tab 50 in your folder, these crimes include willful killing of civilians, like the civilian shot in the head by a Russian soldier when he started filming a column of military vehicles on his mobile phone. Intentionally directing attacks against civilian objects, such as the civilian bus that was fired upon by Russian forces near the village of Veloky Yar in Kharkiv region on the 26th of February, killing the driver and 2 passengers and injuring 18 more. Attacking or bombarding towns, villages, dwellings or buildings that are undefended non-military objectives. For example, the attack on Kharkiv Regional Clinical Children's Hospital No. 1 on the 25th of February, which was left without electricity after being hit 20 times by Russian shells, forcing staff to ventilate numerous vulnerable patients manually. And intentionally directing attacks against buildings dedicated to religion, education, as well as against places where the sick and the wounded are collected, such as the shelling of an ambulance transporting a wounded Ukrainian serviceman in Kherson region on the 26th of February. All of these acts, documented by the Prosecutor General, are expressly prohibited by the Rome Statute. They all occurred in the opening days of Russia's so-called special military operation, before Russian forces had closed in on densely populated civilian areas. Similar war crimes from this initial period of the conflict have also been reported by NGOs active in the field, including New Direction, whose report you will find at tab 51 of your folder. I'm afraid, though, that much, much worse has happened since these incidents and is yet to come. Having failed to secure their military objectives in the first week of their invasion, Russia today is resorting to tactics reminiscent of medieval siege warfare. encircling cities, cutting off escape routes, and pounding the civilian population with heavy ordnance. Today, that is the fate of Mariupol, as reflected in this photograph. According to the town council there, the situation is dire. Mariupol continues to live without electricity, water, and heating due to constant shelling by the Russian occupiers. Twice in the last 2 days, Russia has agreed to open a humanitarian corridor out of Mariupol, only to resume shelling so that civilians could not use it. Today, Mariupol. Tomorrow, or the day after, it may be the turn of Kharkiv and Kiev. These next two photographs, for example, show the damage already inflicted by Russian artillery on residential apartments in Kharkiv and in Borodyanka, a town on the approach road to the Ukrainian capital. The inevitability of further war crimes, if this carnage continues, is guaranteed by the indiscriminate nature of the weapons Russia is already using and others it has deployed to the battlefield, but whose use has not yet been confirmed. Grad multi-launch rocket systems have been implicated in numerous attacks on civilian targets across Ukraine. The use of cluster bombs by Russian forces has also been reliably documented. Perhaps equally concerning, though, as the use of these barbaric weapons, is the fact that Russia is reported to have deployed its TOS-1 platform to Ukraine. The thermobaric rockets fired by this platform, also known as vacuum bombs, literally suck the oxygen out of the air to produce a longer blast wave than conventional bombs. Inevitably, this level of violence unleashed by the Russian Federation has created a massive humanitarian crisis. As Michelle Bachelet, the UN High Commissioner for Human Rights, reported to the Human Rights Council on the 3rd of March, over 2 million people have been forced to flee their homes. 1 million, according to UNHCR estimates, are internally displaced. A further 1,040,000 refugees have sought safety in neighbouring countries in the past 7 days, often after travelling for days by bicycle or on foot in freezing conditions. UNHCR has estimated that up to 4 million people could leave the country in the coming weeks if the conflict continues. The scale and speed of this refugee crisis is unprecedented in recent European history. As the High Commissioner for Refugees, Filippo Grandi, said in a statement the same day, the 3rd of March, in just 7 days, 1 million people have fled Ukraine, uprooted by this senseless war. I have worked in refugee emergencies for almost 40 years, and rarely have I seen an exodus as rapid as this one. Indeed, so fast-moving is this crisis that by the 5th of March, just 2 days later, the UNHCR website was recording that more than 1.5 million Ukrainians had sought refuge in neighbouring countries. These raw statistics do not tell the full story of human misery involved in the refugee crisis, with families separated and homes abandoned, perhaps never to be seen again. The TV footage of fathers waving goodbye to their wives and children after putting them on pack trains to Western Ukraine, while they stay behind to fight the Russian army, is nothing less than heartrending. But the impact on internally displaced people, though massive, is only part of the story. Less visible, but potentially far more deadly, is the humanitarian crisis now developing in the numerous Ukrainian towns and cities ringed by Russian forces. For this much larger number, the present is grim, exposed to the indiscriminate firepower of Russian artillery, with food running short, and in some cases, water and electricity turned off by their assailants. A glimpse of the misery suffered by this group is provided by this photograph of children sheltering under a now destroyed traffic flyover from the shelling in Irpin, Kiev region. We will all have seen the television footage last night of people scrambling to get out of Irpin, with civilians losing their lives to Russian shells in the process. Bad as things are today, however, they can only get worse with every day that the Russian military campaign continues. As if all this human suffering was not enough, Russia's military action also poses grave environmental risks, not only to Ukraine, but also for the wider region. This is especially relevant given the court's statements in its advisory opinion on the legality of the threat or use of nuclear weapons, that the obligation on states to ensure that activities within their jurisdiction or control do not adversely affect the environment of other states applies in the context of armed conflict. A full-scale military invasion like that we are witnessing today involves countless environmental harms, many irreversible, a full description of which would fill a library. In the interest of time, I will mention two only. First, the world has witnessed with growing unease the Russian armed forces' recklessness with regards to the impact of its actions on Ukraine's civil nuclear industry. In the opening days of the invasion, Russian vehicles swept into the Chernobyl protected zone, tearing up radioactive soil and increasing the background level of radiation in the area 20-fold. Fortunately, the new safe confinement structure, which you can see in this image, completed in 2016 to seal off the remains of Chernobyl's damaged reactor number 4, appears not to have been damaged in Russia's military operation to date. Concerns over Russia's disregard for nuclear safety reached new highs in the early hours of the 4th of March, when Russian forces shelled the nuclear power station at Zaporizhzhia, the largest nuclear facility in Europe. You'll find at tab 55 in your folder a statement of the 4th of March by IAEA Director General Rafael Mariano Grossi, reflecting the seriousness of the situation that morning. Again, the world was fortunate that the resulting damage affected only a training facility and none of the 6 reactors located nearby. These were near misses, to be sure. In both cases, Russia's military aggression could have resulted in a new nuclear catastrophe affecting not only Ukraine or Russia, but potentially a vast surrounding area. And with the IAEA now expressing concern about the Ukrainian nuclear authorities' inability to communicate with the staff operating these facilities, the danger is far from over. Second, in an attempt to deprive Ukraine of fuel, Russia has attacked numerous fuel depots, releasing vast clouds of toxic smoke into the atmosphere. For example, this photograph shows the aftermath of a Russian missile attack on a petroleum storage depot in Vasilkiv, near Kiev. There have been numerous other attacks of this kind since Russian operations began on the 24th of February. Yet, In another indication of how Russia turns truth on its head, Ukraine has information that Russia is handing out gas masks to local militants and the Russian military in Donetsk in preparation for a false flag operation involving the blowing up of industrial tanks with chemicals. You will find a diplomatic note from the Ukrainian permanent representative to the OPCW describing this plan in more detail at tab 56 of your folder. These incidents demonstrate the utter disregard of the Russian military for the environmental consequences of their actions. The longer their operations continue, the more likely it becomes that this disregard will translate into an environmental disaster of epic proportions, with severe and enduring results. In my remaining time, I will show how the appalling human and environmental consequences of Russia's invasion of Ukraine satisfy the conditions of irreparable harm and urgency to which the court looks when considering the appropriateness of provisional measures. First, there can be no doubt that much of the harm currently being inflicted on Ukraine based on false allegations of genocide will be irreparable. The court has frequently stated that loss of life constitutes an irreparable harm. Thousands of people have already been killed in this conflict. Ukraine regrets the unnecessary loss of lives on both sides. While neither the Ukrainian military or civilian population provoked this conflict, and while they will do everything in their power to repel the invasion now directed against them, it is equally true that many Russian soldiers had no idea what mission their deluded leadership was sending them into. The sad fact, however, is that with every day that passes, more lives will be lost, and probably at an accelerating rate. Alongside the loss of life, for millions of Ukrainians, life will never be the same again. For the million who have fled to neighbouring countries, there can be no certainty that they will ever return to their homes, or if they do, that those homes will still be standing. Those who have been separated from family members left behind in Ukraine cannot know if they will ever see those relatives safe and well again. For both the refugees and those unfortunate enough to be trapped in Ukrainian cities awaiting a Russian military onslaught, the future promises lasting psychological trauma. Finally, much of the environmental damage inflicted on Ukraine by the Russian invasion will likely prove irreparable in the near to medium term. The Chernobyl disaster of 1986 teaches us that the effects of nuclear accidents endure for hundreds and even thousands of years. The CO2 being released as a result of Russia's scorched earth tactics will likewise linger in the atmosphere for the long term, compounding the effects on climate of the greenhouse gases already to be found there. In addition to threatened irreparable harm, each of the indicators of urgency to which I referred earlier in my remarks is amply satisfied here. In short, there is no doubt that unless this court acts now, irreparable prejudice will be caused to Ukrainian rights before the court gives its final decision. Indeed, that irreparable prejudice is happening now and only grows with every day that passes. First, it almost goes without saying that the population of Ukraine is extremely vulnerable to the violence being inflicted on it by the Russian Federation. Millions are trapped in cities that are being ruthlessly bombarded and lack food, electricity, and water. According to Ms. Bachelet, who I quoted earlier, 1 million more are internally displaced within Ukraine, and the UNHCR's latest figures show that 1.5 million more are now living as refugees in neighbouring countries. It is hard to conceive of circumstances in which a civilian population could be more vulnerable than this. Second, the overall situation is extremely fragile, and the risk of aggravation of the crisis is acute. Ukraine stands on the verge of a slaughter of more innocent civilians. As we have seen in Mariupol in recent days, just as we did in Aleppo in the not-so-distant past, Russia has no compunction, once it has surrounded a city, in simply bombing it into oblivion. Kiev, Kharkiv, and maybe Odessa are next on the list for similar treatment and have vastly greater populations, most of which are still sheltering within those cities. Bad enough as that is, the fragility of the situation reaches beyond Ukraine, into Europe and across the world. Neighbouring countries may well be destabilised by the resulting humanitarian crisis as the conflict enters its next stage. A nuclear or other environmental accident triggered by Russian military action would have consequences across the region. And hard as it is to believe, President Putin's brinkmanship in raising the alert state of Russia's nuclear forces has placed the entire world at jeopardy of strategic miscalculation by an increasingly out-of-touch Russian leadership. Finally, the harms already suffered by the Ukrainian people will recur on a daily basis until Russia's invasion stops. Unless the court acts now, the human and environmental impacts I described earlier will intensify and continue until Russia has achieved its ultimate goal, whatever that may be. In conclusion, Madam President, distinguished members of the court, Ukraine submits that this is an urgent case and that the court should act immediately to prevent foreseeable, irreparable harm by indicating provisional measures. My colleague, Professor Harold Honju-Ko, would explain why the provisional measures we request are appropriate under these urgent circumstances, and I ask you, Madam President, to give him the floor next.
Thank you for your statement, Mr. Kimball. I now give the floor to Professor Harold Honju-Ko. You have the floor, Professor.
Madam President, distinguished members of the court, I'm honored to present Ukraine's prayer for provisional relief. This court is no stranger to tragedy, but it is rare when you confront a case that combines such callous brutality with such brazen illegality. As you've heard, this case is fundamentally about Russia's lies. Russia lies about the facts when it claims that Ukraine is committing genocide. Russia lies about the law when it claims that its obligation to prevent genocide entitles it to launch a punitive special military operation against so-called neo-Nazis that we all recognize as an offensive war of aggression and atrocity against Ukraine's peaceful people. Our presentation has provided an anatomy of those lies. As Professor Tuvinen explained, Ukraine contests both Russia's factual lie and its legal lie, thus creating the dispute relating to the interpretation, application, or fulfillment of the Genocide Convention that vests this court with prima facie jurisdiction. You've heard from our agent, Mr. Kornevich, and Mr. Zayats about Russia's reign of terror throughout Ukraine, why the whole world watches. The effort to disguise that illegality by the illegal recognition of the LPR and the DPR, and the absurd lie that it is Ukraine that's committing genocide against its own people. In our other ongoing contentious action, we presented to you the precursors to these horrors, but the world's failure to set limits on Russia's past adventurism has only emboldened President Putin to move beyond the financing of terrorism in the Donbass and pervasive racial discrimination in Crimea to commit even more flagrant, brutal violations of international law throughout Ukraine. Ms. Cheek's presentation identified Russia's bad faith abuse of the Genocide Convention and the plausible rights that will be the subject of the proceeding on the merits. And Mr. Gimlet just explained why the situation on the ground is so urgent and the harm to Ukraine's people so devastating and so irreparable. So all three prerequisites for the indication of provisional measures under Article 41 are satisfied: prima facie jurisdiction, plausible rights, and irreparable harm. Which brings us to the language of Article 41, which grants this court power to indicate such provisional measures as are appropriate, quote, if it considers that circumstances so require, close quote. To decide what measures are appropriate under these circumstances, you should treat this as a singular case, which until now most of us have contemplated only in the hypothetical. A permanent member of the United Nations Security Council decides, with planned premeditation, to commit naked aggression and war crimes by launching a broad and brutal military campaign against an innocent neighbor and its civilian population based on the false pretext that the target state is committing genocide. When confronted by such open illegality, is this court utterly powerless to stop it? And can that P5 member stubbornly continue that abuse, paralyze the UN system, and immunize its actions from international law? The answer to these questions must be no. But in the face of Russia's concerted and shameless aggression, what can and should this court do? Obviously, you should act immediately to prevent irreparable prejudice to the rights of the Ukrainian people and of Ukraine. You should order the parties to prevent the aggravation and extension of their dispute under the Genocide Convention. But the court's provisional measures have a broader purpose as well: to prevent nullification of the legal issues in the case by prohibiting the respondent state from creating a fait accompli before you can decide on the merits of the claim. This court is uniquely positioned to issue the direct measures that would stop the carnage and preserve the legal position pending a hearing on the merits. In so doing, as Judge Locke wrote in the Lockerbie case, in fact, the court is the guardian of legality for the international community as a whole, both within and without the United Nations. As the Supreme Court of the United States announced more than 200 years ago in the landmark case Marbury versus Madison, it is emphatically the province and duty of the judicial department to say what the law is. Faced with a powerful political actor defiant toward its authority, that court clearly declared that the legal instrument at issue provided no legal authority for flouting bedrock constitutional norms. Similarly, as the principal judicial organ of the United Nations, your duty here is to make the prima facie determinations under the Genocide Convention that announce that the court will not abide Russia's flouting of that treaty's bedrock norms. Since the Genocide Convention entered into force, we've come a long way in building a network of international and transnational law. The court may take judicial notice that within days of Russia's invasion, related matters have already come before many other international organizations. The UN General Assembly which has adopted a resolution calling for the immediate withdrawal of Russian forces from Ukraine. The International Criminal Court, which, as you've heard, has received referrals of the situation from 39 states. The UN Human Rights Council, which has established an international commission of inquiry for Ukraine. The European Court of Human Rights, which has issued an interim order requiring that Russia refrain from military attacks against civilians and civilian objects. Regional organizations and nation states, which are imposing a vast web of rigorous sanctions on Putin and his accomplices based on their illegal activities, and national prosecutors who have already begun to launch investigations into whether Russia's leaders have committed the crime of aggression. Within its own legal mandate, each of these bodies must do its own job. So if you speak clearly and decisively now, you will not act alone. Other parts of the international legal system will act in concert with you, focusing on other aspects of Russia's aggression. But amid this broad network of legal activity, your order is the essential spark that will inspire other competent international organs and agencies to take the further steps necessary to protect peace, security, accountability, and human rights in this rapidly deepening crisis. For that reason, we ask you clearly to declare, prima facie, that there is a dispute between Ukraine and the Russian Federation relating to the interpretation, application, and fulfillment of the Genocide Convention. In particular, Article 1, which addresses obligations of states to prevent and punish genocide, and Article 4, which addresses punishment of those who commit genocide. Ukraine further disputes that Russia has any lawful basis whatever to take its military action in and against Ukraine for the claimed purpose of preventing and punishing genocide. Whether or not Russia chooses to appear, declaring the existence of a prima facie dispute between these two countries is warranted in this case. Ukraine further asks that you find no plausible evidence that Ukraine has committed the non-existent genocide for which it has been accused. In particular, first, that no acts of genocide as defined by the convention have been committed in the Luhansk and Donetsk oblasts of Ukraine. Second, that it is plausible that the special military operation declared and being currently carried out by the Russian Federation is based on a false and fabricated claim of genocide that has no basis in the convention. Not only is there no serious risk that genocide will be committed by Ukraine, there is no risk whatsoever. Third, that lawfully the Russian Federation cannot take any action under the Genocide Convention, military or otherwise, in or against Ukraine for punishing or preventing an implausible alleged genocide based on its false claims of genocide in Luhansk and Donetsk. In so indicating, the court should make clear that under the convention, the targeting of Ukrainian civilians and civilian infrastructure can never, under any circumstance, be a lawful exercise of a country's obligation to prevent genocide. And even if Russia scrupulously complied with the law of armed conflict, which of course it is most assuredly not doing, acts of aggression against Ukraine's defenders can never be a lawful exercise of a country's obligation to prevent and punish genocide. And fourth, that the Russian Federation may not invoke a false claim of genocide committed by Ukraine as a legal basis to justify the actions of the Russian Federation in recognizing the independence of the so-called DPR and LPR. Now, within this broader factual context, other international bodies, including the International Criminal Court and the European Court of Human Rights, are exploring the scope of accountability for particular actions by Russia, its leaders, and its proxies. But given this court's special, unique status in international law, the whole world is looking to you for guidance and leadership. Once you have fulfilled your role, these other bodies can fulfill theirs. A recognition that Russia has no colorable legal basis in the Genocide Convention for its brutal actions in Ukraine would provide ample legal grounds for the first two specific provisional measures we request. These measures are clearly linked to the rights asserted by Ukraine regarding Russia's bad faith invocation of the Convention and Russia's abuse of its rights under Articles 1 and 4 of the Convention. Under the first provisional measure requested, the Russian Federation shall immediately suspend the military operations commenced on 24 February 2022 that have as their stated purpose and objective the prevention and punishment of acclaimed genocide in Luhansk and Donetsk. Far from being unprecedented, this court has ordered similar provisional measures before against an ongoing military operation being committed by a permanent member of the UN Security Council. As you well recall, in Nicaragua versus United States, this court declared that the United States of America should immediately cease and refrain from any action restricting, blocking, or endangering access to or from Nicaraguan ports, and in particular the laying of mines in the port of Corinto. That order added, as yours could as well, that the right to sovereignty and to political independence possessed by Ukraine here, like any other state of the region or of the world, should be fully respected and should not in any way be jeopardized by any military and paramilitary activities which are prohibited by principles of international law. In particular, the principle that states should refrain in their international relations from the threat or use of force against the territorial integrity or the political independence of any state, and the principle concerning the duty not to intervene in matters within the domestic jurisdiction of a state, principles embodied in the UN Charter. In October 2008, this court ordered both Russia and Georgia, as parties to the armed conflict in South Ossetia, to do all in their power to ensure that public authorities and public institutions under their control or influence not engage in acts of racial discrimination. And the court ordered similar relief when indicating provisional measures in Congo versus Uganda, declaring that both parties must forthwith take all measures necessary to comply with all of their obligations under international law, in particular those under the UN Charter. Second, Ukraine requests that the Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation which have as their stated purpose and objective preventing and punishing Ukraine for committing genocide. Recently, in the Gambia v. Myanmar, the court's provisional measures order similarly extended not just to members of the respondent states' military, but also to the same group of other actors, any irregular armed units which may be directed or supported by it, and any organizations and persons which may be subject to its control, direction, or influence. In issuing this second provisional measure, the court should take account that no purported obligation to prevent genocide or any other manufactured legal justification could justify either the deliberate targeting of Ukraine's democratically elected political leaders or Russia's failure to take all necessary precautions in attack, resulting in de facto targeting of those leaders. And there should also be no doubt that no act in this war is lawful or authorized by the Genocide Convention, so that the only way to preserve the status quo and protect Ukraine's rights is to order a complete suspension of Russia's military operations. Again, this is not unprecedented. The court has regularly given direction to parties regarding the movements of armed forces and personnel in ongoing military operations. In Cambodia versus Thailand, the Priya Vihir case, in 2011, the court issued an order on provisional measures nearly 50 years after the operative judgment, directing that both parties shall immediately withdraw their military personnel currently present in the provisional demilitarized zone and refrain from any military presence within that zone and from any armed activity directed at that zone. Similarly, in Burkina Faso versus Mali, the court ordered both governments to withdraw their armed forces to such positions or behind such lines as may be determined by an agreement between the governments or failing such an agreement by the chamber. In Costa Rica versus Nicaragua, the court likewise ordered each party shall refrain from sending to or maintaining in the disputed territory any personnel, whether civilian, police, or security. Madam President, members of the court, there is a clear link between these first two provisional measures that Ukraine requests and the plausible rights Ukraine seeks to preserve while its application is pending. As you've heard, the risk that Russia will irreparably harm Ukraine and its people in the name of preventing and punishing a non-existent genocide is very real. Unless Russia halts its military operation, Ukraine's plausible claim that Russia is violating and abusing the convention will only be heard when it's too late. As Ms. Cheek explained, the rights that Ukraine asserts are grounded in Russia's bad faith performance of its obligations and its abuse of its duty to preserve and punish genocide under Articles 1 and 4 of the Convention. The first two provisional measures share a direct link to Ukraine's right under Article 1 to good faith performance of the Convention by any state party. Russia's abuse of the Convention is the source of its claimed authority to use force in Ukraine. Thus, provisional measures by your court directed against that lawless use of force would directly target the abuse of rights at issue here. Third, Ukraine requests that this court direct the Russian Federation to prevent any aggravation or extension of the dispute by refraining from any action and providing assurances that no action is taken that may aggravate this dispute or render it more difficult to resolve. This court gave similar direction when indicating provisional measures in Congo, Uganda, directing that both parties must forthwith prevent and refrain from any action, and in particular any armed action, which might prejudice the rights of the other party and aggravate or extend the dispute or make it more difficult to resolve. The court gave nearly identical directive in its order in Cameroon, Nigeria, again declaring both parties should ensure that no action of any kind, and particularly no action by their armed forces, is taken which might prejudice the party's right in respect of a future judgment or otherwise aggravate or extend the dispute before it. Given the level of atrocities that are multiplying daily and that you heard of from Mr. Gimblett, the court should further order Russia not to aggravate the ongoing dispute by refraining from violations of human rights and humanitarian law in the course of military activities. In the Gambia versus Myanmar, you recall this court gave specific instruction that entities under its judicial supervision shall not commit genocide, conspiracy to commit genocide, complicity in genocide, or attempts to commit genocide. In Congo, Uganda, the court likewise ordered that both parties must forthwith take all measures necessary to ensure full respect within the zone of conflict for fundamental human rights and for applicable provisions of humanitarian law. Less than 3 months ago, in Armenia versus Azerbaijan, the court ordered the parties to protect from violence and bodily harm all persons captured in relation to a conflict who remain in detention and ensure their security and equality before the law. The threat to the Ukrainian people is no less urgent. Fourth and finally, Ukraine requests that the Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court. The gravity and rapidly evolving nature of the situation in Ukraine, which has changed by the hour, call for a clear and ongoing reporting requirement to monitor Russia's compliance with the order you may issue. Regular public reporting, as was ordered in the Gambia versus Myanmar, can allow you more directive rulings in the future if monitoring demonstrates that Russia has refused to comply until the court can render final decision in this case. Like the other measures we request, the fourth measure has the express goal of protecting the integrity of this proceeding before the court and assuring that the court is properly equipped in due course to decide the merits of Ukraine's claim. Whether or not Russia chooses to appear and defend in these proceedings, it would be subject to the court's prima facie jurisdiction under the convention and should be required to account for its compliance with binding orders of the court. To be clear, the preliminary relief we request will not be the final relief requested. On the merits, Ukraine will seek final declarations of illegality, specific assurances, guarantees of non-repetition that the Russian Federation will not take any unlawful measures in and against Ukraine, including the use of force on the basis of its false claim of genocide. In time, Ukraine will seek full reparations for all damages caused by the Russian Federation as a consequence of any action taken on the basis of Russia's false and fabricated claim of genocide. But those requests are for later. For now, we ask not that you give final relief, only that you indicate provisional measures in such a way that leaves that possibility open. Madam President, members of the court, in less than 2 weeks, this case has become much bigger than just Ukraine versus Russia. It has become a test of who will prevail, Russia or the post-war international legal order. The tragedy we are all witnessing in the streets of Kyiv, Kharkiv, Mariupol, Kherson, Volnovakha, and so many other Ukrainian cities is precisely what our modern international legal system was designed to prevent. Just 77 years ago, we, the peoples of the United Nations, determined to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, and to establish conditions under which justice and respect for the obligations arising from international law can be maintained, created the United Nations and this court. But what is the point of having these bodies if they do not act strongly at this moment of transparent aggression and injustice? Madam President, members of the court, President Putin's short game is force. the world's long game is law. For the other institutions to do their job inside and outside the UN system, first, you must do yours. The court's limited role at this juncture is to order the urgent measures of protection that we request that would enable the convention and the broader UN system of which it is a part to work as intended. But if this court does not act decisively against this level of aggression and atrocity based on outrageous abuse of one of the world's most important human rights treaties, rest assured, this would not be the last such case. Putin's aggression and atrocity would not end with Ukraine. If this court cannot decisively order Russia to stop its military actions, grounded in flagrant abuse of and disrespect for the Genocide Convention, why should any permanent 5 UN member see international law as a meaningful obstacle to whatever it might perceive as necessary military action? Then why wouldn't we be forced to concede that the post-war international legal project has failed? Madam President, members of the court, that cannot be the outcome here. Of course, there are limits to what the principal judicial organ of the United Nations may do. But by issuing decisive provisional measures, you can meaningfully preserve the status quo, follow precedent, while leaving room for complementary action by other international bodies. The provisional measures Ukraine requests are reasonable, achievable, and grounded in the very measures you've granted in the past. You have undeniable legal authority to act. Anything less would fail to vindicate the rule of international law under these most dire of circumstances. For all of these reasons, we ask you immediately to issue the provisional measures order that Ukraine so urgently requests. Madam President, members of the court, the world awaits your actions. I now ask you to give the podium to our co-agent, Ms. Zolotaryova, who will present Ukraine's final submissions. Thank you.
I thank Professor Ko, and I now give the floor to the co-agent of Ukraine, Ms. Oksana Zolotaryova. You have the floor, madam.
Madam President, distinguished members of the court, I am honored to conclude Ukraine's oral pleadings and make Ukraine final submissions regarding its urgent request for the indication of provisional measures. Ukraine has now faced 11 days of Russia's brutal invasion of Ukraine. Many people said we could not withstand Russia's aggression for so long. They underestimated the people of Ukraine. They underestimated our spirit, our unity, our devotion. Ukrainian heroes are bravely defending Ukraine, and we will keep defending Ukraine until the aggressor leaves. Ukraine is being supported by the civilized world. We are grateful to each and every act and effort to support Ukraine, but we need more help. We need more help from our allies. We need more help from every institution in the world. That includes this court. Your power to act is clear. To defend actions, they are indefensible. The Russian Federation fabricated allegations of genocide out of nothing. It used this horrible lie as a pretext for its unlawful assault on Ukraine. In doing so, Russia cynically abused the Genocide Convention. Russia twisted the crime of genocide to justify the crime of aggression. In the name of preventing and punishing the crime of genocide, Russia is committing war crimes and crimes against humanity. Ukraine has come here before you, the World Court, to seek urgent protection for everyone who lives in Ukraine. As Professor Tuvenan explained, there is no doubt a legal dispute under the Genocide Convention. As Mr. Zayan showed, the reports of UN missions and other natural observers confirm that Russian allegation of genocide is absurd. Marnichik demonstrated Ukraine's right not to be illegally invaded based on a bad-faith abuse of the Genocide Convention by Russia. Mr. Gimblett highlighted the extreme urgency of the situation, and Professor Ko explained why the court can and must order the measures Ukraine requests. I could rest the Ukraine's case here, but in this difficult moment, I am compelled to remind the court of the real human stakes of Ukraine's requests. As I am speaking, the Russian Federation continues its relentless assaults on our cities, on our towns, on our villages, on our people. This assault has taken many forms. My hometown of Kharkiv suffers for days from indiscriminate shellings, but heroically resists. Churches are ruined, hospitals are ruined, universities are ruined, civil infrastructure is ruined there. None of this can be considered as legitimate military target. The world is witnessing and documenting how Russia kills civilians in its indiscriminate attacks. We don't know yet the true number of Ukrainians that Russia has murdered in the past 11 days. We can only guess how many more will be murdered in the next 11 days if this senseless aggression does not stop. In these extraordinary circumstances, Ukraine requests that the court order the following provisional measures. A. The Russian Federation shall immediately suspend the military operations commenced on 24th of February 2022 that have as their stated purpose and objective the prevention and punishment of a claimed genocide in Luhansk and Donetsk Oblast of Ukraine. B. The Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operation, which have as their stated purpose and objective preventing or punishing Ukraine for committing genocide. C. The Russian Federation shall refrain from any actions and shall provide assurances that no action is taken that may aggravate or extend the dispute that is subject of this application or render this dispute more difficult to resolve. D. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order and then on a regular basis to be fixed by the court. Madam President, members of the court, before I conclude Ukraine's case on its request for provisional measures, I would like to refer to the words of the Secretary General of United Nations, Antonio Guterres, immediately following the resolution of the General Assembly condemning Russian actions. And here I quote, "People of Ukraine desperately need peace, and people around the world demand it." End of quote. On behalf of the government of Ukraine and on behalf of the people of Ukraine, I thank you for your attention in this matter of national life or death. I respectfully urge the court to issue your order with utmost urgency. We are in your hands. Thank you.
I thank the co-agent of Ukraine, whose statement brings to an end the hearing on the request for the indication of provisional measures submitted by Ukraine in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. I would like to thank the agent, co-agent, counsel, and advocates of Ukraine for their statements. In accordance with the usual practice, I shall request the agent of Ukraine to remain at the court's disposal to provide any additional information the court may require. The court will render its order on the request for the indication of provisional measures as soon as possible. The parties will be advised in due course as to the date on which the court will deliver its order in a public sitting. Since the court has no other business before it today, the sitting is declared closed.